At what point do you and your client start the judgment enforcement process if prior collection efforts have been unsuccessful? Attorney Art Matthews explains, if we send demand letters, make phone calls, and still cannot resolve a debt, whether the debtor is ignoring us, unwilling to pay, or otherwise being unreasonable, the next step is to discuss filing a lawsuit with our client. There are certain factors to consider before we file a lawsuit. Primarily, do we think the debt is collectible? In some cases, it may not be worth the client's time, money, or effort to pursue a debt. That can happen where the debtor is going out of business or where there is no guarantor, where the debtor has already been served with other lawsuits, where there are tax liens, or the debtor is insolvent. Sometimes the best decision is to just write off bad debt. Obviously, we hope that is not the case, but it does not do us or our client any good to pursue uncollectible amounts, especially, as in most collection cases, we are working on a contingency basis where we are paid only if we recover. If we suspect there are collectability issues, we can have an asset investigator run a report on the assets and liabilities of the business, including the existence of other lawsuits. We will do that if we are unable to secure this information directly from the debtor. Even if a debt is collectible, we also need to consider whether our attorney's fees are recoverable. For example, if we are suing for $10,000, the client probably does not want to spend $11,000 to collect the $10,000 that is owed. However, if it is agreed to work on a contingency basis, that is not an issue because the client is not advancing attorney's fees. They will be paying out-of-pocket costs, but these are generally less than $1,000 to $1,500. So that is another pre-lawsuit consideration. If we're working on an hourly basis, can we get our attorney's fees back? Does it make economic sense for the client to pursue this? Lastly, we look for any issues with our documents. Is the debt too old? Is there a valid defense? Is it possible that we sue only to have the debtor file a cross-complaint against our client? If there is a chance that the client might file a lawsuit and get sued right back, it might be best just to let it go, especially on smaller claims. Maybe we will push for an early settlement instead, or perhaps a mutual release agreement with the debtor and just walk away if that is the correct thing to do for the client. Overall, we work through the process on a case-by-case basis, depending on how much is at stake and how aggressive the client wants us to be. Matthews Law Firm's primary goal is to provide high-quality legal services for a fair and reasonable price. We welcome any opportunity to help clients fight for their corporate rights.